afternoon, everyone. Thank you for joining us for today's online talk, which will be starting shortly. For those who are here early, thank you for waiting patiently. For those who are here early, we would like to share with you a short video from the firm.
I founded the firm in September 1985 with the vision of seeking truth and justice for our clients and not just winning their cases. Over the years, the team has achieved many significant milestones. We are today recognized by the Legal 500, Asia Law Profiles, and Asian Legal Business as a recommended firm in various practice areas. While we have embraced technology to make our services efficient and responsive, we continue to grow on the bedrock of meticulous preparation and hard work, for which there is really no substitute. As legal practice becomes increasingly international, we keep ourselves ahead of the curve with our relationships with lawyers from around the world. Our firm is a founding member of the Legal Lawyers, a growing international network of law firms in 20 Asian and European countries.
We believe in partnering with our clients to protect and grow their business. We achieve this by holding firm to our values of integrity and justice, while giving our best to deliver effective and efficient solutions. Instead of just legal services, we focus on developing great working relationships based on understanding and respect.
The firm invests in its team and emphasizes professional development. We are keen to share our knowledge and publish our articles on our website. And we also give back with our corporate social responsibility activities. We cultivate a passion for the law and enjoy what we do. This brings out the best in us for our clients today and tomorrow.
We regularly advise foreign clients, including many Chinese investors, and have a ready appreciation for different ways of doing business. In corporate matters, we offer relevant and commercial solutions, often raising issues that clients may or may not have realized before. In negotiations, we believe in facilitating win-win outcomes.
Welcome, everybody. Thank you for joining us for today's online talk on alternative dispute resolution, an introduction to mediation. My name is Chiu. I'm an associate with Mohd and Associates. I will be the moderator for today's session. Before we start today's session, allow me to introduce the firm and what we do. Mohd and Associates is a mid-sized law firm that was founded in 1985 by Datuk Weng Kwai. Our able team today comprises of 22 lawyers and a support team of 18. Datuk Ma is today a consultant with the firm following his retirement from the Court of Appeal bench in 2015. The firm continues its tradition today of working primarily with small-medium enterprises, family businesses, and individuals. We are a full-service law firm with a corporate department, a dispute resolution department, including litigation, adjudication, and arbitration, a dedicated employment department, and a department focusing on servicing the needs of individuals and families. Our practice groups indicate some of our focus areas, which are supported by talents from both our corporate and dispute resolution teams. Today's talk is part of our MWKA online talk series. We have been organizing monthly lunch talks at our office since 2013, some of which were also broadcasted live. But with the COVID-19 Movement Control Order, or MCO, we have moved online in order to continue with our objective of sharing knowledge, raising awareness, and to encourage networking with clients, potential clients, and in-house counsels. Please feel free to visit our website at mawengkwai.com for more information, to read our articles, and to sign up for more of our upcoming talks. Our upcoming talk will be on the legal aspects of digital transformation. Before I continue, please be reminded that this talk does not constitute a legal advice. In the event you require specific legal advice to your matter, please contact us for a complimentary legal consultation. Details will be given at the end of this talk. Now, allow me to introduce both our speakers for today. Firstly, we have Ms. Diana Cheak. Diana began her practice in Mohd & Associates as an associate in 2014 upon her admission to the bar. Diana's primary areas of practice includes mediation, corporate and commercial litigation, employment, as well as industrial relations. Next, we have our next speaker, Ms. Anis Muhammad Sohaimi. She began her practice in Mohd & Associates as an associate in 2018 upon her admission to the Malaysian bar. Her current primary areas of practice include general litigation, debt recovery, contractual disputes, Sharia estate planning, professional malpractice, and also criminal defense. Our speakers hope to complete today's talk by 3:45 p.m. and thereafter proceed with the Q&A session. So if you have any questions, please don't forget to post them up on Slido and our speakers will address them later. You should have received the link to Slido during registration, but I'll leave this slide up for a while so you can scan the QR code before we move on. Alternatively, you can go to Slido's webpage and key in the code 095773. It is also shown on the slide here, 095773. With that said, I will now invite Diana to share her insights. Over to you, Diana.
Thank you, Chiu. Good afternoon, everyone. Today, Anis and I will be sharing our views on alternative dispute resolution, which is mediation, a brief introduction to mediation. So I'll begin by introducing what is a mediation. Mediation is defined under Section 3 of the Mediation Act as a voluntary process in which a mediator facilitates communication and negotiation between parties to assist the parties in reaching an agreement regarding a dispute. So the keywords here are voluntary, facilitates, and agreement. So a mediation is a voluntary process whereby a mediator will facilitate the communication and negotiation between parties. And at the end of the mediation process, if parties are able to reach an amicable settlement, then parties will record an agreement. For more information on what is mediation regarding the process and mechanism, you can read our article, Mediation Process and Mechanism, on our website. All right. The objectives of a mediation can be divided into 4. So, following a mediation, we want an amicable settlement to be reached between parties, and the settlement agreement must be acceptable to parties. It must be done in a conciliatory manner, and the mediation is to be concluded expeditiously, and it is final. When can we enter into a mediation? Short answer is anytime. If parties have already commenced the suit in court, then mediation can be entered into by parties at any stage of the court proceedings. So what are the differences between a traditional dispute resolution and an alternative dispute resolution, particularly mediation? As we all know, arbitration, adjudication, mediation, they are all alternative dispute resolutions as compared to traditional dispute resolution, which is litigation. So in a litigation process, it is formal, it is adversarial, where you have a plaintiff, a defendant, and the record of the proceeding is usually public. But for a mediation process is private. It is only between parties. It is voluntary, very flexible because it is a private mediation, so it is confidential, and whatever that is discussed in a mediation is without prejudice. In a mediation, parties focus on needs and interests as opposed to position and rights in a traditional dispute resolution, which is litigation. What does this mean? I would give a very simple example. For example, in a tenancy dispute, where a tenant failed to pay rental to the landlord. So according to law, the landlord will have legal rights over the property or over a house, and the tenant will have to pay rental to the landlord. So in a situation where a tenant defaulted payment of rental, this dispute is brought forward and parties enter into a mediation. So after the mediation, it is discovered that tenant can't pay rental because he is out of job for 3 months. And at the same time, the landlord needs workers to support his businesses. So what the parties do in this kind of situation is where the landlord may ask the tenant to work for him. The tenant can ask the landlord the landlord can ask the tenant to work for him in order to discharge the tenant's obligation to pay the outstanding rental. So this is where we say we focus on needs and interests of parties as opposed to position and rights. So in this kind of situation, the landlord will get workers to work for him to support his business. Tenant will get a place to stay. That is a simple example of needs and interests as opposed to position and rights. So in a litigation process, we all know that it is a very lengthy court proceeding. It usually involves very high costs. But in a mediation process, it is often time and cost efficient. And in a litigation process, a decision is made by a judge, but in a mediation, solution or decision are made by parties facilitated by a mediator, except for matters regarding constitutional law, prerogative writs, temporary or permanent injunctions, election petitions disputes, proceedings under the Land Acquisition Act, judicial review, certain appeals, revision of court, disputes that brought to the native court, and criminal matters. The rest of the disputes can be mediated. So mediation is applicable almost any kind of disputes other than those that are not applicable here. So who can mediate? Yeah, accredited mediators and paneled to the Bar Council Malaysian Mediation Centers. Judge in a matter, then we call it this type of mediation. We usually call judge-led mediation. Dispute, or we can get a mediation and panel to the KLRCA, and also you can also appoint a mediator agreed by both parties. So in brief, I'll explain the process of mediation. So before a mediation, first we will have a pre-mediation conference where in this pre-mediation conference, mediator will meet parties and then explain the mediation process. So in this pre-mediation conference, the mediator will have to explain to the parties the mediation process, and they have and to understand the facts of the case or the dispute, to disclose any potential or actual conflict of interest, and parties will sign the agreement to mediate at this pre-mediation conference. At the start of a mediation, the mediator will start off with an opening statement where the nature and process of mediation will be explained to parties. Parties will have to confirm that they have the authority to settle. The mediator will also inform the parties that mediation is confidential and it is to be conducted without prejudice. Yeah. So after that, parties will we will sit in the first joint session, where in this session, parties will identify what are the issues, and then they will acknowledge each other's concerns, needs, and interests. And any issues are to be clarified during these sessions. Parties can also start to explore alternatives and opinions at this session. So after the first joint session, parties will sit in a private session with the mediator. So each party will have an equal time and opportunity with the mediator. So usually in this private session, parties share confidential and sensitive issues to the mediator. So after the private session, parties will then proceed with the second joint session. So in this second joint session, usually parties will focus on needs and interests and develop options and alternatives. Then if parties are able to resolve their dispute, they are able to come to a consensus, then they will enter into a settlement agreement. So at the agreement stage, parties will then test the viability of the offer or the agreement. The settlement agreement will be recorded in writing, and it is to be signed off by both parties. So a mediation is governed under the Mediation Act 2012. So under this act, it is stated that the mediation does not prevent commencement of court action. So you can start an action in court and then later enter into a mediation, or you can be in the midst of an arbitration and then you opt for mediation. A mediation also does not stay court proceedings. So mediation and court proceeding can go hand in hand. It can be done simultaneously. The Mediation Act governs the appointment and termination of mediators. It specifies the role of the mediator and conduct of mediation. So as I mentioned earlier, settlement agreement, it will be recorded in writing and signed by parties. So if the settlement is reached by way of a mediation during the course of a proceeding, then parties can record before the court a consent judgment. Okay, what about costs? So cost of mediation usually is to be borne equally between parties. Under Mediation Act 2012, it is also specified that mediation communication is confidential unless disclosure is made by consent, is required for purpose of any civil or criminal proceedings, or you require disclosure for implementation or enforcement of the settlement agreement. So everything that is communicated during the mediation is confidential and it is without prejudice. Yeah. Okay. Unless under the Mediation Act 2012, it is also stipulated a mediation is a privileged process where it is not subject to discovery or be admissible in evidence, or in other words, it is without prejudice. Unless parties waive this privilege in writing, or certain documents is required to be disclosed under the Evidence Act, like a public document under the Evidence Act, or there was a threat to inflict bodily injury, or it is used to commit a crime, or if the mediation is intended to be used to plan a crime or to commit or conceal a crime. And then last and not least, privilege is also not applicable if mediation is used to prove or disprove a claim or complaint of professional misconduct or malpractice filed against a mediator, the party in the mediator, or representative of a party in the mediation. Okay, my colleague Anis will explain on advantages of a mediation and also introduce online mediation to you. Over to you, Anis.
Thank you, Diana, for taking us through the procedure of mediation. Let's go into the advantages of mediation is based on what Diana informed us, is that the relationship between parties can be salvaged and may prevent and resolve future disputes in the future. And a reason that people resort to mediation also is because it improves access to justice, especially to those who cannot afford lengthy litigation, and it saves time and costs and is the guarantee of confidentiality. So knowing all this, how do we now know how to make the best out of mediation, which is going on into our next topic. So you need to understand that the main underlying principle of mediation is that it's based on a needs and interests above position and rights principle. So how this works is you need to understand the difference between rights, enforcing your rights, and upholding your positions, and reaching a compromise to get something that suits your interests and needs. So in simple terms, you can say that positions and rights is basically what what a party says they want, or what they are entitled to under the law, and the interest is the underlying reason why they want it. So position and rights are surface statements where a person stands, and it usually never has any underlying reasons or any motives behind why they take this position. So the interest is where you find where the underlying reasons and values or motivations of why people take the positions. So a classic example that that we would usually give is, say there's two sisters fighting over a whole orange. Both these sisters want the last orange. So so if they were to battle it out, they will not stop fighting until one of them has the last orange. But if you ask each of them why do they need this orange, one sister will say, I want to make orange juice, and the other will say, I need the skin of the orange peel to bake a cake. So you can see how they can reach a compromise by sharing this whole orange. One takes the juice out of the orange and the other just takes the peelings out from the orange. But of course, disputes are not as easy as this. So an example that Diana gave was in the context of mediation. Something that can be resolved through mediation is, for example, of a landlord and tenant. So the landlord's position is that as the owner, he's entitled to rent, whereas the tenant's position is he cannot pay the rent. But if you ask each of them why, so for example, in Diana's situation, she said that the landlord needs rental to provide money for her workers in a separate business, for example. And the reason why the tenant cannot pay is because he's laid out of work. So a compromise between these two situations is that the landlord hires the tenant as his worker, and instead of paying rental, he can agree to waive the rental so long as the tenant works for him. So this is an example of how we can look at situations in terms of interest and trying to find how we can resolve situations by understanding everyone's underlying interest rather than trying to enforce their rights. So how do we imagine preparing for mediation, or whether our situation is suitable for mediation? The first, as I said, it has to be about who is right, and it's not about who is right and who is wrong, but it focuses on interest. So if you are fighting to prove you are right, that's where you take it to court. But if you want, which requires you to always disregard the other side's interest, and it's always just your side matters, your side is right, and you need to enforce your right. But if you consider it as if you consider mediation as like building a deal, like in a commercial context, where if there's not something for each side, you don't have a deal, the deal falls. So you need to be in the right mindset for mediation, to understand that this is something that you need to compromise and understand the other party for you to reach a settlement for the both of you. Next is that you also need to set realistic and reasonable expectations and limits, and you need to remember that making progress is better than trying to enforce your rights, and you need to consider the consequences where there is no agreement. For this, you need to be persuasive, but the way you try to persuade someone, a mediator or the other side, is that you have to see how this solution is mutually beneficial for both sides and not just for you, not just for one side. And a lot of times in the middle of mediation, you will realize that, okay, maybe I'm not so right, or maybe the other person has a point. But oftentimes people like to resort to anger because they think, oh, it's just a natural response, like, oh, you told me I'm wrong now. So it just builds up emotion. But for mediation, you need to be ready to work past the anger, and you need to remember that the point of mediation is to assess the problem, to address the problem, and not to address the person. So you have to identify the problems that each of you face, and you're not there to attack your opponent. And you need to understand that you will not get everything you initially demanded, but it's better than, for example, in a debt recovery case, it's better for you to get something rather than nothing. And this is a possible situation even if you're fighting through court, and the court may give a decision that's not in your favor. Next, you must also take mediation seriously and devote the proper resources. So this includes many things, such as choosing a mediator who attends and who has the mandate to attend. So one of the most important things is who to attend the mediation. Usually a lot of people will try to send the juniors or the one that are more hands-on, but later on they will say that, oh, they have to go back to the heads or the leaders of the team because these are the people who can make this decision. So this is always counterproductive. So you need to make sure that whoever attends, it doesn't have to be one person, but it can be at least you can have two, but it has to be someone who can make decisions, and it also has to be someone who can understand the realities of the complexities of the case, and who in a position to give their opinion and raise concerns in the event that you try to come up with a solution and then you reach a blockade because you don't know what the other side needs or what your company that you're representing is interested in. So it has to be someone who knows both sides, and it also has to be someone who's not just viewing this as like numbers and something that has to be done. It has to be someone who sees a problem and understands that the prolonged problem will create even more problems, so they need to find a solution for this. And another aspect of taking the mediation seriously is choosing when to mediate. So some of the considerations you decide, as Diana said, you can do it before court proceedings or you can do it after. But what you should take into consideration are matters like how the litigation may turn out. Like I said, it could be the case where they have where you have gone through lengthy court proceedings, and then in the end it's a decision not in your favor. Or there could be a case where you've realized there's a case that's similar to your circumstances. The court has ruled against you, has ruled for the opposing side. So this is where you assess your strengths and weakness of your case, and you consider whether you should proceed with litigation or you can try to get a middle ground and go through mediation. So now, having understood what you can get from mediation, the question is mediation even possible during COVID-19 now with all the lockdowns and all the restrictions in place? So our answer to that, of course, is yes, and that is through online mediation. Though mediation traditionally has been face-to-face and physically, actually it has been around, online mediation has been around even before COVID-19. Actually, you may have even experienced it in certain situations where it's not fully mediation, but it has practices similar concept for mediation. For example, if you are like me, you've just recently discovered the world of online shopping. For example, if you go through Shopee, they have the platform for you to report if there's a defect or there's wrong purchases or wrong amount of wrong payment, and you get to put in your problem, and then the other side, say the seller, has his right to see whether he can give you a compromise, whether he can give you a return or refund. So it's from this you can see there's like different sessions. You get both sides of the story, and then you work towards a solution. And you can see how fast this process is, because once parties have put in their details, then a few days later you will get notification whether you've received your refund or you will get a new item. So you can see how there was a problem. If parties wanted to fight about, okay, I deserve this product, I paid for it, I need that money, then obviously you could fight to the end and bring it to court. But because you have this mechanism where you can resolve you can resolve disputes quite efficiently in a timely manner, and you can get the desired result that you want based on what your intentions are. For example, I had a defective product when I purchased something, and it didn't stop me from using it. It just didn't look as nice. So I wasn't willing to go through the hassle of returning and all that. So I just asked him, I asked through the platform if I can get a reduced amount to pay. And I was lucky that the seller was very nice, and he actually gave a full refund. So my first purchase on Shopee was basically free. So that's how mediation can benefit parties, and you see how both interests are protected, because on the one hand I have what I wanted, and on the other, the seller, although he may not have the money, but the reputation of his company or his product is saved. So it guards both parties' position, and it is a solution that is acceptable to both sides. So that's an example of how you may have faced it even before COVID-19 and online mediation. But generally, mediation has moved to being online because there's been a spike of many cases. In a lot of matters are now being brought to court, because I think there's just a lot of access to justice, and parties are more willing to enforce their rights to court. So you can imagine the amount of cases that the court has to go through, and you can imagine that there may be some backlog. So online mediation has been something that's been rising in today's world because of this, so many delays. As the saying goes, justice delayed is justice denied. So we have found many ways to make sure that none of the delays are preventing justice. So now in today's circumstances, because of the movement control order and courts being suspended, there has been even more backlog of cases. So this is why there was a need for online mediation. But apart from that, because of commercial disputes now fast expanding, you can have contracts internationally, and parties are all located in different geographic locations. So mediation has started to accommodate for this growth in commercial disputes and basically business as we know it. So online mediation is something that you can go to because of the different geographic areas. And because business is not restricted by geographic areas, why should dispute resolution be restricted as well? Because in fact, some people are even dissuaded from even settling a dispute because they think of the impending cost, all the trouble it takes to find a place, find a mediator and all that. So online mediation is like a quick alternative. So apart from the needs for mediation, there are many advantages of online mediation. It's convenient and cost efficient. It provides new opportunities and accessibility for like cross-border disputes. Although mediation doesn't really refer to documents as you would at trial, it provides an added benefit that if you needed to share something or a document, you can easily share screen on Zoom or however you use the platforms. But the main advantage is that the setting that it creates, it's less intimidating and it's less confrontational because parties can do it from the comfort of their own home. A lot of times parties will be reluctant to even consider mediation because they have a lot of emotional baggage behind it. So sometimes parties are even more stressed of thinking about meeting the person that they have to resolve the dispute with, right? So online mediation provides a solution to that because you don't have to see the person physically, you just have to look at them on the screen. Hopefully that's a better alternative, and people will be in a better mindset to come up with a solution rather than trying to defend their position and trying to get a win-win, trying to get a situation that's only beneficial to them as opposed to a situation that's beneficial to both sides. So that comes to the end of my part. I pass it back to Chu to take us to the question and answer session.
Thank you, Diana and Anis, for sharing with us. We will now take the questions that some of you have posted on Slido. So for our first question, how much does the mediation process cost? What if the other party doesn't want to mediate? Diana?
Okay, how much does the mediation process cost? Definitely cheaper than litigation. Usually, mediators charge hourly. It is an hourly rate. So if need a mediator, you can contact us directly, and we will prepare a quotation for you. And then what if the other party doesn't want to mediate? You can't mediate unless you have both parties consent to the mediation. So before commencement of a mediation process, parties will have to sign an agreement to mediate. This applies across the board, be it a private mediation or a judge-led mediation in court. So parties will have to sign an agreement to mediate. So if one party doesn't want to mediate, you can't carry on with the mediation.
Okay, thanks. The next question would be, can the mediation process be used even before the court proceedings have started, Anis?
So the quick answer to that is yes. Actually, it's encouraged to do it before the court proceeding starts. And actually, if that's one of the advantages, say for example, if the mediation is unsuccessful, it already gives you an idea of what to expect, because you can already kind of see where parties are leaning towards. But you have to be mindful that whatever is said in mediation cannot be used in court proceedings. So yes, it can be used before court proceedings, and it's encouraged.
I would like to add on a little bit on that. Well, in order to encourage parties to go for mediation even before any party starts to sue in court or commence any action in court, and this applies in usual contractual relationship between parties, what you can do is to include a mediation clause in your whatever agreement that you sign in, be it a sales and purchase agreement or any agreement that you enter into. Include a mediation clause so that if there is any dispute, parties will have to exhaust the mediation process before they fight in court.
Thanks, Diana and Anis. Our next question is, who is the mediator? Are they lawyers or professional mediators? Where can we find them, Diana?
They can be lawyers. They can be professionals in their own respective industries. They can be judges if it is judge-led mediation in court. Where can you find them? There are a list of accredited and certified mediators and paneled with the Malaysian Mediation Centre. You can find it. You can Google the Bar Council Malaysian Mediation Centre, and you can see there is a list of certified and accredited mediators with their expertise. You choose according to the nature of your dispute. That's how you choose your mediators.
Our next question, how do you typically initiate the mediation process, i.e. convincing the other party to mediate? Anis?
There's many ways well, first of all, I think you just need to inform your intention of mediating. But convincing someone it's how you would convince anyone to do anything. You really just need to, although you have you may not be in a good position or not have a good relationship, you need to convince the person that this process will be beneficial for both parties. But how normally when parties are stuck, usually you will get that's why the mediator comes in, because it's a neutral party to convince so before you have a mediator, you may have a lawyer that will convince the other side's lawyer. So yeah, you just get a neutral party to help convince others. Otherwise, you will have to go back on whatever relationships you have, and just to remind how you want to continue the relationship between each other, and you don't want to just stop the contract or just go on about fighting over your problems, but you both want to find a solution. So you just need to convince them that you just don't want to fight. You want to find a solution so that both parties can just move on from the process. It's not human to want to fight. It's many ways you can convince a party to mediate. Do you have anything to add, Diana, on whether you faced?
Well, in reality, one party must. In reality, I think the intention of the party is very important. If you just have to accept, put down whatever emotional baggage that you have, and then, of course, then you can propose mediation to the other side. And usually, I would say mediation is always beneficial to both parties because you address needs and interests. So you get whatever that is necessary to you, and usually it is far more you get far more satisfaction than winning a litigation, because there are instances where there are clients who come to me and say that, look, I get a paper judgment at the end of a litigation, a lengthy court process, after spending so much money and so much time in court, and I won. I get a decision in my favor, but it is a paper judgment. The other side is not going to pay me anything, and I have to go for enforcement proceeding in order to maybe seize the other person's property in order to satisfy the judgment sum that is awarded to me. So I often get this kind of complaints or inquiries from clients. So in order to avoid this kind of disappointment at the end of a lengthy court process, why not try mediation? Yeah, try mediation where you get to resolve whatever dispute almost immediately, and it's often faster than a lengthy court process.
Thanks, Diana and Anis. We will now move on to our next question. For disputes between neighbors on noise pollution, can we go for mediation, Diana?
Of course you can. Of course you can. You can go for mediation if your neighbor is making a lot of noise, maybe at the later part of the day. Then because this kind of if this kind of dispute is being brought to court, possible action that you may get against the other side is an injunction, maybe to stop the other party from maybe making noise at a certain hour of the day. But then to get such an injunction, it may take time. So go for mediation. Parties meet face to face, either physically or online. Let out whatever that is boiling inside, and then find a solution to it. So yes, the short answer is yes, you can.
Thanks, Diana. We have another question. Can parties resort to mediation more than once for the same dispute, or is there other alternatives, Diana?
Okay. Can parties resort to mediation for more than once for the same dispute? Usually mediation, if it is, usually it will take a day for maybe about 4 to 5 hours. But there are also mediations that are extended to maybe 2 days for because there are many issues that parties are dissatisfied with. But more often than not, the main issues are only maybe 1 or 2, but the rest are clouded by other issues, because parties who come for mediation are very emotional. Yeah. So if you need more than one session, yes, you can have more than one session. Or if there is any other alternative, mediation itself, it is an alternative dispute resolution. It is usually an alternative dispute resolution to litigation.
Thanks, Diana. The next question would be, what do you think of mediators giving their opinions to the parties or evaluative mediation? Anis?
In terms of giving opinions, mediators can give their opinions to parties, but the mediator can never impose those opinions on the parties. It's up to them to come to a solution themselves. And generally, they do sometimes indicate, but it's never the basis of reaching a solution. It's always the parties that have to come up with their solutions, and the mediator really facilitates in trying to get a win-win situation for both parties.
I would like to add a little bit on it. As a mediator, I would give opinion when usually on matters like to test the viability of the offer. Let's say if I think the offer is not realistic, I will give opinion and just say, look, this is not realistic. Even if you put this in the settlement agreement, do you think the other side is going to comply with it? And the answer is no. So if the answer is no, then probably you can give some opinions to prompt parties to give alternatives, to give more alternatives and to explore more options. But a mediator cannot impose opinion that is one-sided, I would say. Then the mediator would appear to be biased. Yeah. So this kind of opinion is not encouraged, but opinion like to test whether or not it's feasible to have this kind of settlement, terms of settlement, or like what this participant asked, evaluative mediation, to evaluate whether or not such an option is realistic or feasible, then yes, I would say such an opinion the mediator can give.
Thanks, Anis and Diana. As we are now running short of time, we will now end the Q&A session with the next 2 questions. In a sale and purchase agreement, mediation clause usually not there. because of the specific purpose of purchaser, how do we add a mediation clause? Diana?
How do we add on the mediation clause? You can add on to it. Are you saying about a standard sales and purchase agreement? Usually, let's say, if I am presented with an agreement that needs my signature on it, and if I think that I want to add a mediation clause on it, I will just add it on before signing the said agreement. So that is usually the case. So if you are negotiating an agreement with the other party, then you will have a back and forth negotiation, right? It's always good to include a mediation clause as an alternative dispute resolution clause in the agreement.
Thanks, Diana. Our last question for the day: what is often the reason you would advise not to mediate?
If the dispute falls under non-applicable category, disputes like it touches on fundamental liberty of a person under a federal constitution, for an example, then you can't mediate. Or it is a criminal matter, you can't mediate. I will outright tell the parties in dispute, you can't mediate such a matter. Other than that, as a mediator, I would always encourage mediation, because really it saves a lot of time, and because it is a voluntary process, parties are more likely to abide by the terms and conditions that they have agreed.
Thanks, Diana. And that's the end of our Q&A session for today. Thank you, Diana and Anis, for insights. Before we conclude, I have a few announcements to make. Please join us again for upcoming talks. You can sign up by scanning the QR code shown here or visit our website at mutually-agreeable.com. Please do follow and like our social media accounts. If you would like to speak to one of our lawyers, we offer a complimentary 30-minute consultation over the phone or over video conference. You may fill in the form on our website, and the link is also posted in our chat. Thank you, everybody. We hope you have found today's session informative and useful. We hope to see you at our next talk. Stay safe, practice physical distancing, and have a great day.
Thank you, everyone.
Thanks, everyone.